Good evening everybody. By the previous video, we have completed discussion up to article 207. Today, let us discuss 208, 209, 210, 211 and 212. Of course, from 208 to 211 do not require much explanation and they don't have any controversy also. But in the interest of comprehensiveness, I will discuss each and every article and I will dilate wherever there has been a misuse, misunderstanding or misinterpretation during the last 75 years. In other matters, I will just mention what is contained in the article and move forward. Article 208 says that the Assembly of a state has power to make rules for its own conduct. Article 209 says the Council of a state, if there is one, shall have power to make rules for its conduct. 210 informs us about the languages in which the business of the legislature shall take. It is the language of the state or an official language if declared one, or English or Hindi. 211 says that there shall not be any discussion on the conduct of High Court judges in the legislatures. Now let us come to Article 212. This is a bit controversial and important to understand and which has been misused. Article 212 says that the judiciary shall not interfere with legislative proceedings even if they are irregular. Article 212 clause 2 says that the officers of the legislatures of the state are also free from judicial interference, namely the Speaker and Deputy Speaker of the Assembly, the Chairman and Deputy Chairman of the Legislative Council. In conduct of their business, judiciary cannot interfere. Taking advantage of this, in 52nd Amendment of 1985, during the tenure of Rajiv Gandhi, Anti-Defection Bill was introduced and passed, which is called Anti-Defection Law. It is added under Schedule 10 of the Constitution. Certain disqualification was prescribed for the members of the legislatures of the Union and the states as well. It says that if any person having elected on the ticket of one political party defects to other party, he loses his membership. He ceases to be member of the legislatures. However, one exception was provided that if 1/3 of a political party defects from one party to the other, such defecting members will not get disqualifications. It is a dangerous provision made without application of mind, because instead of anti-defection bill, it has become a wholesale defection encouragement bill. Instead of members going singly, it suggests that they should go in groups to be safe. It is a very dangerous proposition. If one or two members migrate from one party to the other, nothing serious may happen. But if 1/3 of a political party defects from one party to the other, there is every likelihood of the government falling through a no confidence motion. But the losing party will not keep quiet. Immediately, the Council of Ministers will advise the governor to dissolve the assembly. Unfortunately, the governor is also readily accepting such advice and recommending or reporting to the president to dissolve the assembly. So the word of the chief minister is becoming law. This is being done under Article 356. But the purpose of Article 356 is not this. It reads, if the President of India is of the opinion that the administration of the state cannot be run in accordance with the provisions of the Constitution based on the report of the governor or otherwise, he may dissolve the assembly and the government as well. But unfortunately, Article 356 is being used for political purposes at the whims and fancies of the chief minister. However, in the anti-defection bill, it was provided that the power of deciding about the disqualification of the defecting members was given to the Speaker of the Assembly. This is a serious lapse. In fact, it is the governor of that state who is authorized to decide on the disqualification of members under Article 192. he will decide impersonally because he has nothing to do with majority in the legislatures. Whereas the speaker is a member elected by the majority party. If members come into his party, he will welcome. If members are going away from his party, he will not cooperate. We have seen several of such instances. Of late in Telangana, about 7 members have migrated from BRS party to the Congress party. BRS party has filed a petition in the High Court and then in the Supreme Court that the Speaker is not taking decision, seeking direction to the Speaker to take a decision within 3 months. We have seen just now in 122, in legislative proceedings, the judiciary cannot interfere. Under this anti-defection bill, consideration of the disqualification of members is defined as a legislative proceeding. As such, in fact, judiciary is prescribed from interfering with this process. However, Honorable Supreme Court has given a direction to Telangana Speaker to decide. He will decide whatever he wants. He will simply say that the other members have argued that they have not defected. The Speaker will accept such explanation so that the members are not disqualified. Of course, the Honorable Supreme Court has also done the same thing with regard to Tamil Nadu Governor. It has given direction to assent or reject a bill within 3 months, otherwise the bill is deemed assented to. It is most unjustified. It is a mistaken notion. If the President is bound to assent, the word of the majority party leader becomes law. So he will enact the laws, he will implement the laws. He is acting as the legislative leader as well as the executive of the state. This is not democracy. There should be separation of powers between the legislative and the executive. Be what it may, up to this article 212, the only takeaway is that the judiciary is proscribed from interfering with legislative proceedings, and the officers of the legislatures, namely speakers and chairmen, the judiciary is not supposed to interfere with their functions. Since this video is very small, I would also like to add Article 213 into this. 213 is the legislative power of the governor. When there is emergency, not that kind of emergency under 352, where there is a pressing need and the legislatures are not in sitting, they are in recess, but the matter calls for urgency. In such cases, the governor is entitled to issue ordinances under Article 213. These articles have force of law. All the conditions applying to the laws to be made in the legislature shall also apply to these ordinances. Supposing a law, if passed in the assembly, may be illegal, may be void. The same way, if an ordinance is issued for the same purpose, ordinance also will be vitiated. And also on those issues which are reserved for the consideration of the President, the governor is not supposed to issue ordinances. But this ordinance will be alive until 45 days after the legislatures reassemble, unless approved by the legislatures. This is the legislative power of a governor. Unfortunately, we are under the wrong impression that he should act in every case in accordance with the advice of the chief minister. In fact, the chief minister should belong to the party of the governor, and all the ministers are appointed by the governor under Article 164, and their terms of office are during the pleasure of the governor. Their purpose is to aid and advise the governor in discharging his functions. Of course, they are not entitled to advise the governor in matters which require the discretion of the governor himself. Such is the low category of ministers in the presence of the governor. I told you several times in my previous videos, the two divisions of the legislatures are, one is a ruling party and the other is an opposition party. Ruling party at the center is represented by the president, his appointed ministers, and the parliament members belonging to the party of the president. And in states, the governor and his appointed ministers and the MLAs and MLCs belonging to the party of the governor, namely the party of the President of India. or their coalition members. These represent a ruling party, while all other parties or its coalitions would be treated as opposition parties. Sometimes opposition parties may be in majority in the legislatures. They can pass any bill whatever they like. Governor has to assent to each and every bill is a misconception. Governor has three options, either to assent to the bill or to withhold the bill or to return it to the assembly with modifications, or he may reserve it for consideration of the president under Article 201. When these four powers are given to the governor, how can anybody say that the governor must assent or must return? In fact, such conditions are not there under Article 200. Moreover, under Article 159, governor took a oath to preserve, protect and defend the Constitution of India and the law, and to devote himself for the service and well-being of the citizens of India. Having taken such a lofty oath, how can he pass a bill which is against the Constitution, which is against the established law, which is against the welfare of the citizens of India? As such, please be informed that the governor is not required to give assent to each and every bill sent by the state legislatures. Supposing the legislatures pass a resolution to sever them from the country, should the governor assent to such bills? And of course, please also be informed, passing of a bill is the stand of, or not passing a bill is the stand of the opposition parties. Then its assenting or not assenting is the stand of the party of the president, represented by the governor. Finally, it is the people who decide whether the opposition is right in passing or with not passing a bill, or the executive is right in withholding the bill. That is the beauty of democracy, and that will reflect in the ensuing general elections. That is the reason why it is kept in Article 212 that the judiciary shall not interfere with legislative proceedings. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments. Thank you.